Real estate agency. Real estate is a relationship-based business, so it is critical to understand the rules surrounding client-agent relationships. The law of agency governs the relationship between clients and agents in a real estate transaction. The legal terms for the parties to an agency relationship are principal, the person hiring an agent. In this context, think of agent as a legal term for a person hired to represent someone in some matter and not necessarily a real estate agent. In real estate, the principal could be the client hiring the broker, or the principal could be the broker hiring the real estate salesperson, depending on the context. The principal has vicarious liability for the agent's actions. This means that if you are the client who has hired the real estate agent, anything that they do on your behalf within the authority you have given them is as if you have done it yourself. Similarly, anything a real estate agent or salesperson does on the behalf of their broker within the scope of the authority they have been given is as if the broker has done it him or herself. Universal agent may represent their principal on any matter. Best example here is a CEO of a business who has been given full board approval to make any decisions for any aspect of the business: hiring, investing, purchasing, product development, etc. General agent may represent their principal on matters related to one particular business or activity. This could be a property manager who handles all aspects of a client's real estate business, or a sports agent who handles the entirety of someone's career. Special agent may only represent their principal on a particular matter or transaction. In real estate, this is the real estate broker, referred to as the employing broker or broker of record. This could be a property manager who handles one single apartment building, or a broker who handles the sale of a condo for a client. Subagent, the agent's agent. In real estate, this is the salesperson, co-broker, etc. A subagent works indirectly for the transaction's principal via the special agent's authority and works directly for the special agent. This is the salesperson or associate broker who works on behalf of their employing broker or broker of record. Binding power refers to an agent's ability to enter into a legally binding agreement on behalf of the principal. A universal agent has unlimited power to bind the principal. A general agent has limited power to bind the principal, and even though they are special, a special agent has no power at all to bind the principal. There are 3 types of agency that might exist between these parties: express agency, explicitly stated or verbal in writing; implied agency, authority that exists because of the principal and agent's actions, even though it never is directly stated. The Equal Dignities Rule states that an authorization of agency must have the same formality as the services rendered. If so, a written agreement is required. Written agency agreements are probably required as well. Think of this as the agent's corollary to the statute of frauds. Apparent or obstinable agency, authority that does not exist even though it appears to. Real estate agents, both brokers and their salespeople, owe fiduciary obligations or obligations of trust to their principals. You can remember these obligations with the acronym OLD-CAR. O, obedience. You must do everything the principal tells you to do, and you may not exceed the authority they give you. However, obeying the principal's instructions is not an acceptable defense for unlawful or unethical behavior. If the principal gives unlawful instruction, the agency relationship must be refused or terminated. Loyal. You must put the principal's interests ahead of all others, including your own. Disclosure. You must affirmatively disclose all information about the transaction that might affect the principal's best interests. Confidentiality. You must not disclose any confidential information about the principal to others. For example, the highest price that they might pay or a weakness in their bargaining position that you are not legally required to disclose. Account. You must account for, return in any money belonging to the principal. And reasonable care. You must protect the principal from foreseeable risks of harm, exercise care and confidence, and recommend expert advice when the principal needs are beyond your expertise or area of competence. Note that no legal advice is allowed under the licensing law. Massachusetts also requires brokers to engage in fair and honest dealings with the principal, known as implied duty of good faith, under MGL 93A. When it comes to fiduciary obligations and old car, it's important to be aware of the differences between clients and customers. Clients are people that you represent and owe fiduciary obligations. Customers are people that you are working with but do not represent, therefore do not owe any fiduciary obligations for. For example, an unrepresented buyer who attends an open house that you are hosting for your client. Even though you do not owe them fiduciary obligations, you will have other limited legal obligations to them, like fair and honest dealings and some required disclosures. More on below, state licensing law requirements, etc. Confidentiality and required disclosure. When it comes to confidentiality, information about your client will usually fall into one of three categories: information that must be affirmatively disclosed, information that must not be disclosed, and information that might have to be disclosed. Both sellers and buyers' agents are required to inform the buyer of any material defects, also known as material facts, impacting the subject property. A material defect is anything that would objectively impact a buyer's decision to purchase a piece of real estate. Disclosure is required even if the seller wants to keep the defects confidential. The buyer must be told not only about any material defects that impact the property for sale, but also about any that are rooted in the land or permanent and may impact the area around the property. This includes special tax districts, environmental hazards, and in many states, it also includes nuances like airports, highways, cell towers, etc. When a buyer purchases a house on an as-is basis, all known defects still must be disclosed to the buyer. Selling as-is or where-is does not relieve sellers or agents from their obligation to disclose defects. The notion of caveat emptor, let the buyer beware, is not a defense for any failure to disclose material information in real estate sale. It's recommended that the agents use a seller's disclosure form to ensure that everyone is aware of all of the defects of the property that's offered for sale. Buyers must be informed about material defects regardless of when they are discovered. For example, if a defect is found after the purchase contract is signed, the buyer must still be told about it. Buyers' agents also have an obligation to affirmatively disclose any information about the buyer that would materially impact the buyer's ability to purchase the property. For example, if the buyer does not yet have the funds to purchase the property. That said, information about the parties to the transaction that does not materially impact the property or the ability to conduct the transaction must never be disclosed. For example, the seller's lowest price that they would take or the highest price a buyer will pay or why the seller is selling. If an agent does somehow learn confidentiality information about the other party in the transaction, though, they must disclose the information to their client as soon as possible. For example, if the buyer's agent hears that the sellers are moving and are therefore desperate to sell, the buyer's agent must tell the buyer. What about information you might have to disclose? That information has to do with stigmatized properties that were the sites of death, murder, suicides, criminal activity, and paranormal activity. Buyers may find the situation disturbing, but there is no objective impact on their use of the property. Every state handles the disclosure of stigmatized properties differently. In Massachusetts, the seller's agent is not obligated to affirmatively disclose the information, but if the buyer or the buyer's agent directly asks the seller's agent about a property's stigma, they must be truthful and respond with any information that they know. The buyer's agent, on the other hand, has an affirmative duty to disclose a property's stigma information to the buyer. Finally, watch out for Megan's Law issues surrounding sex offender registries. Each state has their own laws regarding the disclosure of sex offenders. Massachusetts strictly punishes the misuse or misrepresentation of those registries by an agent. Therefore, it is advised that agents provide buyers with the information that they need to access in the registry and check the information for themselves rather than represent it. Let me read that again. Massachusetts strictly punishes the misuse or misrepresentation of those registries by an agent. Therefore, it is advised that agents provide the buyers with the information that they need to access the registry and check the information for themselves, rather than represent its contents as the agent. Tristram's Landing versus Waite. Tristram's Landing versus Waite is a Massachusetts court case that establishes the criteria to determine when real estate brokers are entitled to earn a commission. These criteria are similar to the criteria used in most states and will therefore appear on the national portion of the exam as well. It is therefore critical to understand so that you know when a client has unfairly withheld payment versus when they are within their rights to do so. In this court case, a real estate broker sought to recover a commission for a sale of real estate that was ultimately not completed. In the final judgment, the court adopted the following rule. When a broker is engaged by an owner to find a purchaser, the broker earns a commission when they produce a purchaser ready, willing, and able to buy on the terms provided by the owner, the purchaser enters into a binding contract with the owner as a result of the agent's efforts, where the broker is procuring cause of sale. And 3, the purchaser completes the transaction by closing title in accordance with the provisions of the contract. If a deal is not consummated because the buyer lacks the financial ability or because another default with the buyer, then the seller does not need to pay the commission. However, if a wrongful act or interference from the seller leads to the contract's failure, then the commission must still be paid. In summary, the general rule regarding whether a broker is entitled to a commission is that, absent special circumstances, the broker is entitled to a commission if he or she produces a buyer who is ready, willing, and able to consummate the deal under the terms and price the owner has given the broker. Real estate commission math. Based on what information is available, you can calculate the commission using one of these formulas. Sales price, X commission, percent equals commission amount. Sales price minus the costs, including commissions, equals seller's net profit. And net sales price plus costs divided by 1 minus the commission percentage equals the sales price. Other rules that impact real estate agents. FTC, Federal Trade Commission, do not call. Agents are treated as business under the law since the agents often call residential for sale by owner listings as a way to generate business. FTC do not call is in play. The FTC do not call list created in the Do Not Call Implementation Act of 2003 prohibits unsolicited business calls to residential and mobile phone numbers on the Do Not Call list. Financial violations of Do Not Call are up to $43,792 per call. As of 2013, pre-recorded calls or robocalls are also banned without prior written consent of the consumer being called. Also note that text messages are included under Do Not Call rules. Note that an agent can call a for sale owner listing to show the property to a buyer since the owner is soliciting that sort of a call, unless the ad says no agents or principals only. Existing relationships under 18 months are also excluded from the legislation. Telephone Consumer Protection Act and the Junk Fax Prevention Act. Both of these acts prohibit most unsolicited fax advertisements. In order to legally send an advertisement via fax, you must typically have an existing business relationship with the recipient. CAN spam. The Controlling Assault of Non-Solicited Pornography and Marketing Act, CAN spam, of 2003 prohibits commercial electronic messages that do not provide both the address of the sender and some means of unsubscribing or opting out of the future messages. The Children's Online Privacy Protection Act, COPPA. COPPA requires that businesses provide consumers with a detailed privacy policy if they collect information via websites, mobile apps, and other networks. It also strictly limits the collection of personal information from children under the age of 13, even if the website or app is not specifically targeted towards children. Interstate Land Sales Disclosure Act requires sellers of subdivisions to file their intent to sell those lots on an interstate basis with the Consumer Financial Protection Bureau if they meet one of the following criteria. The subdivision contains more than 100 lots or condominiums, or 2, they are offering more than 25 lots or condominiums for sale simultaneously, or 3, the subdivision contains lots size 20 or more acres. This act is designed to avoid fraud when properties are sold without purchasers seeing them, by requiring developers to provide purchasers with a written property report detailing the title issues, development details, utility costs, soil conditions, etc., to provide buyers with a minimum of 7 days to rescind their purchase agreement. Social media advertising. Most real estate agents use social media to promote their business, share listings, and connect with consumers. These posts on social media are a type of advertising and are therefore subject to the same laws, regulations, and disclosure requirements as every other type of advertising. The rules don't differentiate between paid and unpaid advertising. All advertising is covered. So if you use social media in your business, you will need to remember that your social media posts relating to real estate are advertisements. And you will need to be sure you will need to be sure to follow all of the rules and regulations around advertising. This means avoiding things like puffing, misrepresentation, blind advertising, ensuring that you'll fully disclose conflicts of interest, follow state and federal fair housing laws, avoid issues with the Truth in Lending Act, keep adequate records of property availability, never disclose personal information on your clients, and so on. All of the same rules apply on social media that apply everywhere else. There is no social media exception. Many agents prefer to create separate professional social media accounts for their real estate business. That's probably a best practice, because it keeps your personal life separate from your professional life, and it makes it easier to comply with the rules about advertising and disclosures. But watch out. Posts that you make about your business and listings on your personal accounts still count as advertisements, even though they're on your personal account. The various advertising rules and regulations and disclosure requirements that apply to all advertisements, regardless of where they are and how they are made. Finally, if you are a salesperson, your broker will likely have a policy about social media use. Be sure to follow it. And if you're a broker, be sure to establish a policy for your agents so that you can be confident that they'll follow the rules. The Sherman Antitrust Act. The Sherman Antitrust Act of 1890 prohibits anti-competitive business activities and requires U.S. government to investigate organizations suspected of engaging in those business practices, for example, monopolies. The Act forbids price fixing, establishing uniform pricing, group boycotting of a consumer or non-competitor by a group of competitors in any agreements regarding a division of the market by geography or services offered, also known as market allocation, and contingent sales, also known as tying or tie-in arrangements, which makes the sale contingent on the purchase of another item. Recently, the NAR adopted policies to provide for greater transparency of commissions. MLS must now show the buyer's commissions to consumers, and realtors may no longer represent the buyer's commission as free to consumers or to that seller that pays the full fee. Some regional MLSs and brokerages have adopted their own version of these commission transparency rules. Since all of these changes were made to encourage agents to work in their clients' best interests, it's a best practice to follow these guidelines, even if you aren't a member of the NAR. The penalties for antitrust violation are fines up to $1 million per offense for corporations and fines for up to $100,000 and 3 years of imprisonment for individuals. In order to be fined, an antitrust conspiracy must occur, defined as 1, 2 or more people agreeing to an act either explicitly or implicitly, and 2, the agreed upon act having an effect of restricting trade or limiting competition. The key to avoiding antitrust violations is to remember that commissions, contracts, and other hiring terms are always negotiable. There are no standard commissions, and it may be unlawful for agents to even discuss commissions with their colleagues, or for 2 brokerages to discuss the splits that they offer for their agents. Okay, and that is what was this chapter called? Real estate agency.